Don't worry about it. Me going out to the world is, I can see it here.
Okay, good morning, everybody, and welcome to the State Ethics Commission. Today is May 15th, and the time is 9:01. First of all, let's few administrative announcements. If you have a cell phone, please turn it off, and if you do want to be recognized, especially those on the WebEx, raise your hand so we can see who you are. We can have you on the record as identifying yourself, and then you can speak. And with that, roll call. And if you are alone, please indicate.
Thank you, Chair. Recognizing that Commissioners Tobias, Hong, and Thielen are in the public hearing room. Turning to staff, Keith.
President, hello.
Bonita.
Present now.
Barbara.
Present and alone.
Patrick.
Present and alone.
Jennifer.
Good morning, present and alone.
Nancy.
Present and alone.
Jody.
Present and alone.
Miles. I'm going to recognize Miles is present. Would any members of the public wish to introduce themselves?
I'm Judith Mills Wong. I'm here observing from the League of Women Voters.
Welcome, thank you. Anyone else?
Okay, thanks. For the members of the public who are here, I have to read this. If the commission's video conference connection is lost during the meeting, we will recess the meeting and reconvene after connection is restored. Please check the commission's website. It's www.ethics.hawaii.gov for information about reconnecting to the meeting. If the meeting is continued to a later date or terminated, information about this will be posted on our website. So, any questions? Okay, if not, minutes of the April 17th, 2024 meeting. Are there any corrections, commissioners? If not, I'll entertain a motion to approve.
So moved.
Moved by Commissioner Tobias. Is there a second?
Second.
Second by Commissioner Thielen. Any discussion? All in favor, roll call.
Starting with Commissioner Tobias.
Aye.
Commissioner Hall.
Aye.
Commissioner Thielen.
Aye.
Chair.
Chair votes aye, no opposition, motion's carried. Director's report.
Thank you very much. If I can turn it over to Benita to start the education and training report.
Good morning, Commissioners. The information is in your meeting folders regarding the training information and on statistics. We're continuing to provide training to the various live sessions, as well as doing a few mini presentations on request for gift laws and gift reporting issues. We'll also be following up with DHERD and sending out flyers to encourage all human resources departments to incorporate the training requirements as part of their onboarding process for new employees through their LMS systems. So we'll continue to work with the agencies and get updates. We're also going to be, as we get the updates from the board filers on who's members of the various state boards and commissions, we'll also be updating our database to kind of record that information on their training information so that we can provide more specific detail by board to the commission. We're in the middle of filing season. So annual disclosures from current employees and board filers are due May 31st. This week, we just sent out requests to requests for annual updates to all the about 100 board administrators to request their updated board filer lists. So we'll be processing new board members and information. And then finally, candidates, because it's election season, candidates who are running for state elected office will also be required to file this year by June 14th, which is 10 days after the Office of Elections nomination deadline. So the office right now is in a very busy filing season, so staff is working really hard. Thank you.
Any questions from the commission? Yes,
Yes.
Commissioner Thielen.
I just wanted to ask about DAGS, Department of Accounting and General Services, that their number seems to be rather low. And they do have, some of the employees have quite a bit to do with the contracting of DAGs. And I
Yes, so
just
we
think,
plan. Yes, Commissioner. So we plan to reach out to the specific boards that are kind of lower end. I think there's a number that we also been flagging, like DOT, DAGs, DCR. I think is in a weird boat because they gone through a massive reorganization. So a lot of the correctional officers or probation officers may have taken the training under DPS. So we're going to work with the HR to update their information and see if there's any missing individuals. And we're going to recommend to the HR that if there are individuals that don't have a certificate in their file, or when they look up their names on our system and aren't able to locate their certificate or proof of a certificate, we're going to just encourage them to just take the training again on their LMS system so that there's no question. It's half an hour, it's easy, so there should be no issue on their part. It's just these lateral changes sometimes can be difficult for HR officers to track if they're coming from one department to another. So we'll work with them and reach out to those specific departments.
thank you.
Any other
Thank you,
questions
Chair.
from the commissioners? How many questions or comments from the audience or the public? Not? Thank you, Bonita. Keep up the good work. We'll get 100% yet. Oh, we're still working on 85. I know.
I'm doing my best. Thank you.
Robert?
Moving target. Key, if you don't mind addressing guidance and assignment statistics.
Sure. So as you can see, we closed 33 complaints, but we only got 25 new complaints in. So we're closing more than we received. Some of that is just due to the timing of when the complaints come in. So last month was a little lower. This month's a little higher. On the year, you can see that we're pretty much closing everything that comes in. So I think we're moving at a pretty good clip and processing the cases well.
That's good. Does that mean that everyone's behaving himself?
I don't know about that. So we got 152 complaints, but yeah, we're just kind of getting through the complaints.
All right, I guess our training is doing hopefully some good. Yeah.
It definitely is.
Any questions from the commissioners? Any questions or comments from the public? Okay, if not, thanks, Key.
So just briefly on the miscellaneous office projects and updates. No particular update with regards to filling the vacant commissioner spot. My understanding is the Judicial Council received enough applicants and they are in the process of reviewing those applicants. When they submit, under the statute, they're obligated to submit 2 nominees to the governor to choose from only those 2. When those 2 names come in, we will receive notice. We can certainly, let you know or let the public know of those 2 nominees. And then the governor would have, I believe it's 45 days, subject to double checking, to pick from those 2. So hopefully it may be it may be unlikely that we'll have a new commissioner by the June meeting, but hopefully by July we'll have a new commissioner. In addition, we had allocated some money in the budget last year to do a video training, or to essentially create some video online capacity. So we are in the process of looking at trying to encumber those funds and select a provider that can help us in developing that. The idea that we're going to have some optionality as we do our trainings to have some video components and be able to update our online training with that. So that project's in the works. That's all.
Any questions from the commissioners?
No.
Any questions or comments from the public? Okay, if not, thank you very much. Item number 3. Discussion with media reports.
Yes, so as you may recall, this is a standing item that we put in just to give the public or the commissioners an opportunity to talk about any recent media articles that might be of interest regarding either the Ethics Commission or ethics in general. Of the 3 that I flagged happening since our last meeting, we did have a famous celebrity appear in a KITV clip talking about the Ethics Commission. Thank you, Derek, for handling that, talking about what the commission does. It's an important public outreach. We also had a Civil Beat article that I helped write, essentially indicating that the legislature has done some really good improvements and we've made some progress, but we still have a ways to go. And then we also had a follow-up article also published in the Civil Beat, following up on an article we're about to talk about, specifically talking about the pay-to-play practices. The Civil Beat looked at other states and what other states have done to try to address that issue.
Thank you. Any questions, any comments from the commissioners? Yes.
Chair, is this the correct time to talk about the pay-to-play issue and what our role could be?
I don't think so, because it's not on the agenda. Is that correct? Or maybe I'm wrong.
We have that as agenda item number 5, so we'll get.
Okay, I'll wait.
Okay, there it is. Yeah, answer your question. Any other questions or comments? No. Actually, yeah, I was pleasantly surprised that KITV was interested in regards to commission, and they did a good job. I in all honesty, but that they really covered our I thought it was just going to be a blurb, hello, goodbye. But the feedback I got from that, and plus from the article that Robert did a very good job in really highlighting our commission and what we do. So I think that's very positive for us. So thank you. Comments? Public, any comments? All right. Moving right along, legislative matters, number 4.
Commissioners, thank you for the opportunity to talk about this. As you may know, the legislative session has ended and some bills have become acts or become law, and there are a number of bills that are pending before the governor. So I'm going to walk through some that will become law, and also talk about some that are pending for the governor that are of note. And then in addition, finally, I'm going to talk about a few bills that did not pass this year that I think are worth revisiting next year. So as you know, and we've talked already, our budget for next year has been approved. It is a bit lower than what we'd asked for, but it is still well within the scope of what we need to have in order to sort of keep normal operations. So no particular complaints there. In addition, a bill that Chair had actually suggested is now law, which increases the commission's maximum administrative fine, both for ethics violations and lobbying violations, up to $5,000. So that is now law, and it would apply to any violations that occur essentially going forward. So violations that we're getting reports on today, chances are they may still fall under the old limit, but going forward, it's going to start being triggered. As a bit of a rabbit hole, but just a quick side note, I've asked staff to start, and other states have done this, of looking at some type of settlement guidelines with the idea of having something that we would then present to you to adopt, with the idea of having something to look at objectively to sort of determine what is a recommended settlement for certain types of violations. I don't think or anyone envisions that everything's going to be a $5,000 fine, for example. So the idea is having some type of general we'd like to try to get that in place soon before we start seeing violations under this new law. Any questions on those two before I jump into bills currently pending before the governor?
No, I'm glad that was passed, because now, and having been on the commission for such a long time, and the $1,000 fine didn't mean very much. So now $5,000 per violation gives us a heck of a lot of teeth. So I'm glad it was passed. Go ahead.
Thank you for the suggestion. It's a good bill and glad to get through. Bills pending before the governor, and some of these are going to impact us. They weren't necessarily part of our package. That's the reason I'm bringing them up. HB 1915 is a bill that the judiciary helped push through. And I think they're flagging acts of violence against judges. And so this allows a defined class of people to be able to ask that their private information be removed, including, for example, information available from the Bureau of Conveyances, such as where they live, et cetera. So this is primarily focused at judges and legislators and the state elections office. But it does, if approved, it would give the governor and the speaker and the Senate president the capacity to add additional affected individuals. So this impacts us in two ways. One, we host a lot of disclosure information already. It is my belief in reviewing it that we don't currently publish any of the private information defined in here, such as personal addresses. We typically will remove somebody's principal place of address from the financial disclosure, just the value. However, if we are asked to remove personal information, we'll have to review that individual. So again, the way the bill would work, the law would work, if passed, is that individual would have to affirmatively ask us, and we have a defined time period to remove that information. So if someone asks, we'll have to do a review to make sure we indeed don't have any personal information published out there that meets the definition of law. So that impacts us in one way. In addition, I've observed in conversations with some of my colleagues at the ombudsman's office, the state elections office, and the campaign spending office, that threats or acts of violence seem to be increasing. And so, it may be worthwhile for us to consider asking that some members of the staff or commissioners might be able to elect to use this law as well and actually be designated as well. Again, I don't think any of us have had an act of violence or threat against us yet. However, it just seems like the general discourse in civil society is moving in that direction. I'd rather be proactive in this regard versus having somebody, being threatened at their home or otherwise. So just flagging it, it's not law yet, but it may be something to revisit later in the future. Moving on through a couple other bills before the governor. HB 2374. This makes emergency appropriations. This is specific to the hazard pay settlement. And so this also would include the ethics commission. So staff who were working in office as a result during COVID will be eligible to receive some additional money based on a memo that the governor is still finalizing. So how many days they are in office, et cetera, they would now be deemed eligible to receive some hazard pay. SB 2216 is one of the Ethics Commission's package bills. This updates our advice and investigation procedures. Two things it does, I think, of particular note. It helps solidify or clarify that advice we provide to individuals is confidential. I think there was some ambiguity previously. It allows an individual asking for advice to get a written summary, and they can do with that written summary of which whatever they want. But otherwise, conversations with us asking for advice are confidential. And we thought that was particularly important to stress because we want state employees or public officials to reach out to ask questions. We want them to feel comfortable talking about the facts of circumstance and to try to be proactively avoid ethics violations before they happen. So I think this is an important update, albeit, housekeeping variety, but it's important. In addition, it gives the commission the ability to issue general advisory opinions of its own volition. So typically, agencies have the ability to execute policy either by issuing rules, which is a fairly long process subject to public input, has the ability to issue decisions in the case of a specific individual, such as an enforcement case against a specific individual. And the commissions always have the ability to issue advisory opinions, which have somewhat the force and effect of law, talking about the application of particular facts to the law. And it's a tool that previously state employees had to ask for an advisory opinion. Now the commission has the ability to issue a general advisory opinion. And I think where it would make sense is, for example, if we get the same call 10 different times asking, how do I handle this situation? We now have the ability to recommend a general advisory opinion that will be public out there and we can point everyone to. And that helps keep uniformity, makes the public more aware for certain circumstances, and doesn't have to have a situation where we have to answer the same question over and over and over again, and only those people know. So I think it gives a new tool. I think it's an important one, and hopefully one we can use effectively. SB 2217 is just basically adjusting the reporting periods to align for most state employees with the fiscal year instead of the month before. So it's maybe a purely what I call a housekeeping bill. And then finally, SB 3191 is a University of Hawaii bill. They previously had exempted themselves from under the technology transfer exemption from certain parts of the ethics code in order to allow them to, technology transfer, essentially allow some level of privatization research done at the university. And this law always had a sunset provision. UH asked that the sunset provision be removed. So it's now, if signed by the governor, it's going to be a permanent part of law. Any questions?
Questions, commissioners? Any questions or comments from the public? No, thanks, Robert. Moving on. Feels worth revisiting.
Thank you. So we may talk about some of these again later under item agenda number 5. So HB 1884, which is a bill that we had partially got passed last year. So legislators are now required to disclose financial ties with lobbyists. So if they receive income from a lobbyist, they will have to report that and specificity. So previously, for example, if a legislator had a consulting firm and they're receiving money from a lobbyist, they'd only have to report the money received from the consulting firm, not necessarily who paid into that firm. We had asked also that lobbying organizations, so the clients of lobbyists, would also have to be reported. That did not pass in its entirety last year. We were trying to fix it this year. Again, it did not pass. And I understand there's some pushback within the legislature from having to do this. And I think it's a bill that we have to probably just keep pushing. I think it is important that if legislators are receiving money from organizations that are trying to pass bills, that be very transparent and very clear. It helps identify conflicts of interest, and it helps ensure public confidence that decisions are being made fairly accurately, particularly if there are no financial ties. That's good to know. So it's a bill I hope we can try to push again next year.
So that being done in the simplest form, if a legislator is doing business with a lobbying organization, he has to report it or should report it. And then the next question is, does it make a difference if or not?
So the bill did not pass.
Yeah.
So right now, if, for example, a legislator had a consulting firm and a trade organization was one of that legislator's clients, and that trade organization is also lobbying, that would not necessarily be visible to the public. And this bill, which we pushed and made it to conference committee, so we'd like to try to do it again, would require more specific disclosure that trade organization is also paying the legislature, which helps identify to everybody else that, hey, there's a potential conflict of interest there, and that legislator probably should not be involved in any legislation pushed by that lobbying organization. We did not draw any distinction between nonprofits or for-profits. It's just if it's a lobbying organization, of which there are about 400 to 500 of those registered every given year. If you're receiving money from them, that should be transparent.
I guess my example, if I may, then I'll open up to questions. Let's say I work, I'm with the Boy Scouts of America. How's that? And, I have an affiliation and I'm doing something from the legislature. Do I have to report that? That there's a connection between me and the Boy Scouts of America?
So if you are a legislator.
Yes.
And you were receiving money, because there have to be financial transactions.
No money.
So no money, if you were in a board position, potentially like a, sort of a high level position. Currently, if you're on a board, that might be revealed, but if you're receiving money from the Boy Scouts, that would not necessarily be visible.
Commissioner Thielen, yeah.
Yes, excuse me, sorry. Could we, since next year will be a beginning of a new session and the bill would have to be reintroduced, could we put in a good Sesame Street purpose clause? And
I'm sorry, what?
well, I call it a Sesame Street clause, and that's what I used to call it when I always required a purpose clause for any bill I introduced. And it's kind of a Sesame Street approach. You're teaching other legislators what this bill is going to do. Because if you don't put that in at the beginning and maybe be sure that you have in your preamble of the bill the answers to questions that legislators would have. Whenever you're dealing with ethics issues and money issues, they're going to want to know, how will that affect me? So I would like to suggest that all of our legislation that we introduce as the commission have a Sesame Street purpose clause. You solve a lot of problems by answering the questions before they get raised.
It's interesting.
The next challenge is getting the legislators to read it, but at least it's there.
That's the first time I've ever heard the phrase Sesame Street.
That's what I'd always use.
Any other comments from the other commissioners?
I'll support. Yeah. Commissioner Thielen's proposal, because it's not worthwhile just bringing it to committee again. Just saying, well, we encourage this and trying to change something. So I think that you have to do some different approach to try to get it through committee and or both.
I agree with Commissioner Thielen, but can we not use Sesame Street unless we get their permission?
Well, if I see an objection, I'll leave it up to Commissioner Thielen to maybe redesignate or
Well, we're answering questions that are likely to come up by putting in the purpose clause, this is what the bill will do, this is what the bill won't do.
Yeah.
It's not
That's
going
a
to
good
apply
idea.
to this, that, or the other, so don't get all upset in advance, because the bill is very straightforward. It does X, Y, Z. And then you go into what you're changing in the law or adding to the law.
Well, I think Commissioner Tobias, we're all in favor, but maybe rename. There you go. That's amazing. Few of us. Never.
I use that as shorthand because that program was so wonderful in teaching. And it was, the purpose was teach with your purpose clause, then go into how you want to change the law or put in a new law.
I like that. I like that. I think we
all purpose clause.
All purpose clause. There you go. Whatever you call it. I mean, all of us watch Sesame Street, right?
Right.
No, no. Okay. Any other comments from the commissioners? How about from the public? Any comments or questions? Well, anyway, good suggestion. Sesame Street.
The feedback's well taken. I think I'd also add that this is probably one that we need to develop public support for fundamentally, this is asking legislators to disclose more, potentially impacts their ability to have second jobs, second employment, to make money. And I think as a matter of human nature, it's not surprising that folks are less enthusiastic about restricting their activities or restricting their own financial capacity. And so I think this is one that we will have to flag for the public and to try to develop champions and supporters for it, because without that, I think this one will be tricky to get all the way, over the finish line.
Good.
The last bill to discuss on legislative matters is, if you recall, one of the proposals we had expanded the definition of lobbying. Our lobbying laws are largely unchanged since the 1970s when they were first passed. And nationally, a lot of lobbying laws look pretty similar. They're principally focused on interactions with legislators regarding either administrative rules or legislation itself. It does not necessarily cover as much of the executive branch. And there are certain areas of maybe high importance, significance to the public, where shenanigans or problems may arise where increased transparency could be helpful. And so this bill, as it was revised throughout the session, really became focused on procurement interactions, hundreds of millions of dollars of public money to go out here, public contracts. And the idea was to try to get greater levels of transparency between essentially the vendors, the prospective contractors, essentially trying to solicit their goods or solicit a contract with members of the executive branch who have the decision-making authority to issue those contracts. This bill, we got support from the state procurement office. We got support from private individuals who are involved in the procurement process or the procurement council. So I think we did a pretty good job of getting sort of various agencies and other organizations to support it. But as with many concepts, sometimes the first year you introduce it, it's just too new. People don't understand it. I think we need to bring it up again next year and just keep pushing the issue. And really the central focus will be if interactions between executive branch members or even interactions with legislators with outside folks is fine. There's no such thing as bad lobbying. It can provide important information. The intent here is transparency. If one business is really pushing its unique proprietary product and having a lot of interactions with the executive branch, let's have some transparency around that. And competitors may be able to say, hey, my product's better, and here's why. Just allow that to be visible. And the hope at the end of the day is it will reduce the potential for corruption and it will help encourage better competitiveness and better contracts for the state. So,
questions, commissioners? Any questions or comments from the public? Okay, if not, thank you. Item number 5. There we go.
okay. Patrick, I apologize. I didn't. Okay, so I apologize, commissioners. There is a PowerPoint presentation in the materials. I don't think we necessarily need to put that up. So I don't think we planned as well as we should have to happen. Nonetheless, it is in the meeting agenda. We have first as attachment 1, an article we briefly discussed at the last meeting. Chair, you asked us to put it on the agenda for this meeting and to talk about it in more depth. So this article is here. It was published in both the New York Times, I understand it was a front page article, and in the Civil Beat as a collaboration between the two entities. They did an extensive job of looking at publicly available data to come up with some conclusions that I think were surprising even to the Campaign Spending Commission, who actually gathers this data. I mean, it's first of all, hats off to those two media organizations for doing that extensive investigative research. As a complete side note, it shows the importance of financial disclosures and it shows the importance of having that information available because people can use it in unique ways to find out startling conclusions. So, again, congratulations to the community organizations, and also stress the importance of some of the information that we provide publicly, as well as the Campaign Spending Commission. So the general recommendations or things that we looked at, we identified essentially 3 issues as a result of this article. The first,
apply to our commission.
I'm going to identify 3 issues in general
Okay.
that I'm going to designate sort of who's pulling on those
I
issues.
think
$24 million, about 1/5 of all political donations made. Of that total, 6 million has come from people tied to just 15 companies. That's issue number 1. Issue number 2, at least a dozen legislators have worked for or co-owned companies that won state contracts, some profiting in a way that did not previously been reported. Issue number 2. Issue number 3, which I think is a little bit less of an issue, but it's still something to flag, is that state employees engaged in political activity during off hours and helped coordinate contacts between contractors and political candidates. Okay, so 3 issues. The second slide, which is page 43, which is also attachment number 2 to this item. We noted essentially sort of a breakout of those issues, and then sort of flagged the biggest issue, the one of political contributions being given, is largely a campaign spending commission issue. Limits on political donations and overall disclosure of the campaign fundraising really is their kuleana. However, transparency around lobbying, which would be interactions between contractors potentially and government officials, as well as public or financial ties between legislators, public officials, or state employees, is our kuleana. So I think it's a smaller fraction of that bundle of sticks, but it's still, we do have some portion of this, and that's sort of something for us to talk about. So starting first with the Campaign Spending Commission, Campaign Spending Mission kuleana, they have previously proposed an expansion of the government contractor ban to include officers, owners, and immediate family members of government contractors. One consideration for us is whether or not this commission wants to support that bill in the future, but it is a bill that has been introduced, and I suspect will get renewed attention next year, in part because of this article. In addition, under the genesis that, again, we were asked to look at recommendations to make and things that we can do. We have a good relationship with the Campaign Spending Commission. We've broached, I think we should continue talking about ways to make our information and their information more integrated, more transparent, and ways we can support each other to make sure that information is visible to the public. We pause there briefly. That's the campaign sort of political contributions issue. Is there anything people would like to raise or talk about?
comments by, or questions by the commissioners?
Okay. Moving on to ethics concepts. And so again, this is going back to the bill that we talked about previously, which would it be expanding the lobbying definition to capture interactions between contractors and high-level executive employees, something that's currently not public. And the idea would be is to define that as lobbying and require more transparency around it. This would require, ensure more disclosure. So where government potential contractors, potential vendees are interacting beyond a certain point, then they have to start revealing or disclosing those interactions. The second one, which is a little bit of a side note, but I think it is also something to flag. The city and county of Honolulu, about 10 years ago, issued a policy around inaugural events. Right now, when a new executive is put into office, there is some ambiguity about when they're throwing a big inaugural event, whether or not those are political contributions, whether those are gifts, and are they allowed? And the City and County of Honolulu, their ethics commission did issue a policy, I think putting some increased information and I would say more regulation or oversight over that, which I don't think the state has done yet. And it's something for us to look at, which would be timely to do before a new executive officer comes into office. And just as maybe why this is being brought up, you know, those events can cost in the hundreds of thousands of dollars. And, you know, the incoming candidate is going to be looking at typically a lot of contractors and political contributors to donate to those events. And so, you know, making sure that it's not seen or perceived as an opportunity to get increased access to the governor, get unique privileges or some type of unique access. You know, basically trying to create more oversight of that, I think would be potentially be beneficial and squarely within our court. Finally, I anticipate a controversial discussion point, and let's just simply say it's a discussion point. One of the main issues that they flagged is that dozens of legislators received money or owned a business that was doing contracting with the state. One proposal would be is to more greatly or support a prohibition on legislators having outside employment, receiving income during the legislative session or while they're in office. More generally, again, this is a discussion point. The observation that I would have is that since the Constitution's created, the number of constituents each legislator has increased significantly. It's roughly 3 times as many constituents. There is definitely a attraction to the idea of a part-time legislator who goes back and does work somewhere else or does something else. The reality of today that if a constituent calls up a legislator in June and says, I need help with something, the legislator really is not empowered to say, I'm sorry, I'm only part-time, I can't help you right now. The reality is most legislators are, as a matter of function, working full-time. They have to answer in order to stay in office. And so part of this may simply be recognizing the reality that these individuals are largely working full-time, and to recognize that and to correspondingly say, you're not allowed to have other employment. The reality, again, recognizing that they are essentially working full-time, is that there are relatively few opportunities for this legislator to get outside employment that isn't government related. Who is going to be the most interested in hiring a legislator? It's likely to be somebody that is interested in having certain government policies enacted. And so there's just a natural concern there that the ability for somebody to have another job is going to be probably related to trying to get some type of policy passed. And that's why, you know, such a controversial or difficult proposals here is that, you know, ethically, if you want to be clean, you essentially say, if you're here in office, that's your full-time gig and that's what you're focused on. You're not allowed to go work for a government relations business or to consult with somebody about how to get bills passed. Again, there's a lot of, you know, hybrids of this, you know, proposal. There's different things, and all of them are going to be controversial, and all of them probably be difficult to pass. But, you know, you ask for recommendations. This is something to at least put on paper and to have a healthy discussion about, and maybe even start trying to have a dialogue with the public more broadly about as well, about why this might be an important discussion point.
Questions? Yes.
Yes,
Mr.
Chair,
Thielen.
what I'd like to ask, will on your page 45 of our materials of the printout, would the first one, the proposed expansion of lobbying definition, capture that high-level DOT employee who either hosted or was a major participant in the pay-to-play bag event, you know, the money bag event? That's where I think it was, to me, that's still shocking that was occurring. How do we capture disclosure? I know that we can't put in a prohibition, but we could require disclosure from the government employee.
Yeah, very well could, if the interactions are with contractors specific about, procurements, contracts, proposed policies, plans. Though that type of thing would be what would be captured by a lobbying definition. It would not necessarily capture hosting a fundraiser, but I think the perception would be that that should be captured on the campaign spending side. So two different tracks of how that might be captured.
Other questions?
Okay,
Go
yeah,
ahead.
may
No,
I
go ahead.
continue? Yeah, I'm a little confused on that. I mean, I think so how do we get to an ethical disclosure by the government employee?
That they hosted a fundraiser. If they're hosting a fundraiser, that is something that is currently reported, and that's in part how some of this is now visible to the public. If they are attending a fundraiser, I think they would currently only be captured if they actually made a donation.
How about, I mean, not necessarily co-hosting or facilitating. I like that better because hosting could be who paid the bill, and that could be really very limited.
Mhm.
But let's just say hosting a fundraiser. I think people need the ethical responsibility of disclosing that. And that plays two ways in my mind. The participant is going to go, wait a minute, I have to put this out in a public record and state this. Do I want to do this? And that to me is the biggest lesson.
Mm-hmm.
It's not going to be just, we all go trotting down the location near the Capitol and get this little event fundraising going, and all they have to do is disclose what they received.
Mm-hmm.
I want the fact that our government employees are at a high level, ranking level, are taking active measures to be part of this pay-to-play operation.
I understand the concern, and I think I've certainly heard from some individuals who thought that that was sort of the most alarming part of this article. I think it's difficult to do it on our side of the fence. We currently require financial disclosures from a relatively small group of employees. 65,000 or so total state employees in total. I think our total number of disclosures is around 400 of those are disclosing. And of those, many of them are confidential filers, so it's not public. So adding additional questions wouldn't necessarily more publicly reveal it. And the purpose of those financial disclosures is typically to identify conflicts of interest. So they really are focused on financial transactions. So I'm not sure adding to that would necessarily create greater public transparency of what you're describing. My inclination would be is to look at the fundraising statute on the campaign side and look at what is disclosed there and try to work on that, which might include anyone who attends, for example.
But I really feel that employee was acting as a lobbyist on behalf of those, I mean, a volunteer lobbyist, but he was acting as a lobbyist. Bring in all these legislators, hand them these envelopes with big amounts of money in them. And what more is that than lobbying? Saying, okay, come on over. I'm putting the connection between the two of you. Now you legislators, you owe those contracting companies, those executives, those biggies, you owe them something.
Yeah.
And that's to me is a definition of an active lobbyist. So how do we get to that? Is it through the lobbying law, or the lobbying portion of what you're required to disclose, or what is it? That person just walks.
Yeah.
That person hasn't had to do anything.
I want to be really careful just to note that the article is making allegations. And so, obviously we don't have the factual evidence to make specific charges or public allegations.
Well,
against
let's
individuals.
assume
So
a
to
fake
just-
scenario and a fake event. And let's assume that fake event, this high level ranking official from, let's say we're a different country, we're
Yeah.
not Hawaii, no, we've got to be here. Whatever, let's make the whole
Sure.
thing very,
So not talking about the specific set of facts, but more general. Lobbying by definition would require the individual to be paid by the private company. They actually have to receive income.
and they aren't receiving income.
So, arguably in that situation, that state employee is creating greater relationships with government officials and with contractors generally, which one could argue, I'm not making the argument, but just one could
One
argue.
doesn't
that's
know
beneficial.
what that government official receives
Well,
from,
if they do receive it, then
companies.
that becomes an enforcement action from us, right? That potentially they've created conflicts of interest themselves. That's something that we ethically could look into. If that is indeed the situation. It may also simply be that this government official, you have to, part of, the political process is when you get a new executive officer, you do tend to get a lot of new high-level folks that are politically connected. And that has, been a part of American politics for, hundreds of years. So the fact that they have some political connections and or high-level networking is probably part of the reason why they got the office too.
Mhm.
Again, I'm not trying to say it's appropriate or, maybe an appearance of impropriety that should be addressed generally. And yet, the fact that they are going to political fundraisers or being there or being engaged in some manner, I think it'd be very difficult to prohibit constitutionally or pragmatically. That's probably in part how they got to where they are to some extent too. Again, obviously there is some line of which, it starts getting inappropriate, particularly if it's creating conflicts of interest or soliciting contracts for somebody. And again, that might be something that's more of an enforcement action.
Let me interrupt real quick.
Robert,
I'm sorry.
Oh,
Commissioner
sorry.
Grant, we're out of time here. We gotta get out of here. This is an issue. I think it's something maybe we can discuss a little further. Right now, I want to just know what the issues are in regards to this. And then we can come back to it and review, if you have any recommendations, what Commissioner Thielen has mentioned as an issue. I think it's an important issue. I don't think we can resolve it now, but that's a good point.
No, but I would like to at least peel away the surfaces of the onion far enough to get to where there is a role that the Ethics Commission should play and where we should require that kind of a disclosure.
I think that's something.
But on an ethical level, to
Yeah.
me, that didn't smack of campaign spending money. That whole event smacked of ethics.
Yeah.
And
Mind
the
if I
point
take-
was
I'm
that-
sorry, go ahead.
that there should be, whether there has to be a law in place to be able to do the training to say that's inappropriate. And we don't have that law in place. And I guess that's what I'm looking for, is some way to have a law on the books that would say to a high ranking official, any event of that sort is not something that you should participate in or facilitate or host.
Robert, you understand the issue that she's raising? Can
With
you
a-
take
with
that
a-
onion and try and peel it away
With a
for us?
purpose clause.
Yeah. So we'll leave it on the agenda, okay? So I won't resolve it, but those are good issues. That's a good issue.
Chair, I understand the issue, and I think this would have to be one where the commission would direct us something that they want to try to regulate more specifically. I understand what Commissioner Thielen is presenting. I do think it's probably increased transparency around the fundraising side or on the campaign spending side. I'm not quite sure if this is something that on the ethics side, we should prohibit executive officials from participating in political campaign fundraising. I think that would be constitutionally challenging, but if it's the will of the commission to look at that more specifically, we can try to see and craft.
There's a big difference between participating and hosting and facilitating.
I think there's
Big
still,
difference in my mind.
sure, but I think
And
there's still be a.
that's
First
where,
Amendment.
that's where it just came to me that looked to me, if it wasn't unethical, it should have been.
Would you like to make a recommendation to Robert?
I would like to make a recommendation that you look at the level, not just participating, but actually being the host or co-host of events where we have this lobbying and then money going to exchanging, the pay to play. And how do we make this what I think it is unethical? How do we make it legally unethical?
You got that?
I do. Would that apply to the governor as well? Would the governor be prohibited from?
I don't
hosting?
think so. I don't think so, because the governor has to have the freedom. She or he must have the freedom to be able to be in different groups, facilitate, host, etc. No, I don't think so. I think that if it would be going after this, I guess to begin with, very narrowly, and taking the agenda that was laid out in the pay to play article and taking a look at how do we make the high ranking government officials hosting of this be unethical.
So would you envision cabinet members?
I'm sorry, say it
So
again.
like cabinet members? Examples?
No, I'm saying, I think we need to go where the money really is taken care of at the department level.
So would a head of a department be prohibited? And that's a cabinet member, right?
What do you all think? I know under the cabinet level.
Let's hear from.
Well, I agree with you. I think it is a huge ethical dilemma. Because I think that what happens is that once you start regulating and you start parsing out who this would impact and what it would do, I think that's where you're going to run into problems. Because if there's a way to exempt themselves from that accountability, they will find it.
Mhm.
And then the second thing is it really, on the ethics side, is it a gift that somebody is, they're not necessarily hosting, but is it a gift that they're giving them? All of this money or this bag of money or whatever, and what's the implication tax-wise for that? Or do they just kind of take this money and do whatever? Is there any accountability for that money?
I think, maybe giving it back to Robert you developed on page 45, ethics concepts. Or maybe we can, instead of trying to discuss everything now, get some kind of real vision proposal, and then use it as a straw man that we can kind of discuss. Is it going to be adoption of policy regulating inaugural events? Is there something? Yeah, I understand that, this is a bigger issue, but we probably will only be able to take small sections of it at a time.
Is anybody objecting to that? That's a suggestion by Commissioner Hall to give it back. I think Robert understands the issue. Come back with something. I think you got the.
I think what he wanted was that we would like him to do it.
Yes. Is that okay with everybody? Because we can't resolve it today, but it's definitely a big issue. The other question I have is, now maybe I'm mistaken, but is there a prohibition in regards, or we're trying to make a prohibition about legislators having a second job that may be influenced?
Oh, I don't think we're going to be able to do that.
I heard that. Because my legislator friend says, are you kidding me?
I don't think.
I don't think I live on my salary. I'm not talking about the city council, okay? But, okay, I just wanted to make sure. I mean, Emmons, that would be a can of worms.
I mean, again, I think it is a can of worms and squarely understand that. And I think this is something the commission has talked about previously. So it's not a new topic. And I think previously the commission decided to pass on the issue and let others pursue it. I am re-emphasizing it, though, that the number 2 issue was legislators receiving money from government contractors. And one can understand how, even if that is perfectly ethical, it raises an appearance of impropriety that is, alarming and concerning. And so, the reality would be is right now it's generally speaking allowed. And the only way to really address that I'm aware of is either target it to no outside income from lobbyists, lobbying organizations, government contractors, or something of that nature. Or I think, which I think would be even harder to pass, or just a general, you are a full-time employee and this is your 100% of your commitment should be to this job and to your constituents, not to, a telecom or somebody else who's hiring you and paying you, knowing that having legislator on the books is helpful to their general interests.
But isn't it basically, if we have a complaint in regards to that particular issue, we'll look at it. But I don't want us to go out and how many legislators do we have? Do you have a part-time job, by the way? I'm joking.
No.
No.
Did I?
Yeah.
Oh, I'm only running my own private law office.
Yeah, see,
I
so I'm
didn't
saying,
take
I think
over.
we could wait and my
Yeah.
question's already been asked. Wait. It's heavens, I don't want to go out there and say, hey, you got another job here, okay?
Mhm.
But that first issue, I think that's something that I think the recommendation of the commission is come back with some recommendations. Is that okay with everybody?
Yes.
Okay,
And my hope is that we could eventually make it unethical.
Yeah.
Because that just was in my mind.
Okay.
Should have been.
if
unethical.
you don't mind, I'm gonna move along. We got 10
Yeah.
o'clock, we got out here, it's 11:30 up. Anything else from the commissioners? If not, I'm gonna ask the public any comments or questions about this particular issue. Okay.
Chair, if you don't mind, just
Sure,
to
go ahead.
recap.
Sure.
We are going to continue looking at the past bill regulating the procurement interactions with high-level executive officers. We are going to look at adopting a policy on inaugural events. And we are additionally going to look at a ethical prohibition on high-level executive officers on being involved in political, I think it have to be just political activity, quite frankly, for it to make sense. So similar to the prohibition that's constitutionally based for the elections office and the ethics commission, trying to expand a similar prohibition more broadly. And looking at perhaps the constitutionality of such a proposal.
Is that okay with you, Commissioner Thielen?
It's okay.
Okay, so that would be 3 concepts to look at.
Yeah.
We are putting on hold prohibition on outside employment. I would, if you don't mind, do one last 10-second recap on that. That would require quite likely a constitutional amendment. It is not something that we would propose as a bill or get done right away, to be clear, but just even as a general policy matter, supporting the concept may not be a bad thing because it starts the conversation more broadly.
It was just a question. It was just a question.
Yeah.
Because, Chair, that actually ties in with publicly funded elections. Because it would need to do that, I think. And which would be great to add to that conversation.
I don't want to call telephone calls from my legislative friends. Kill me. Commissioner Hall, is that okay with you in regards to?
It's fine. Why do we see this initially goes?
Okay, Commissioner.
Yeah, it's fine with me.
Okay, moving right along then. Thank you very much. Good discussion. Where are we now? I believe item number 6, are we? Okay, judicial oversight.
So we've had good conversations with, so Chair Huang and I have met with the judiciary. We've had good, productive conversations. I think I'll just leave it at that. The judiciary is looking at some proposed rule revisions, and that, there's still sort of a deliberation stage. I sort of want to respect that. Anything that they would do would have to be public facing, so the public would have the opportunity to comment, to be involved. In addition, we are also talking about sort of post some of that, having them come to one of our meetings and do a presentation publicly allowing members of the public to engage or interact with that as well. So again, I think it's moving in the right direction.
Yeah, I want to thank Robert for initiating the meeting. It was, but it was very positive, and they appreciated our recommendations. But it's in their, it's their home court. We're just here to try to facilitate, not tell them what to do. But they're very receptive, so it's good. All right, item number, oh my gosh. Is this still on the agenda? Item number 7. Kana.
So we have attached a number of the documents that have occurred. These are all public documents, which includes the original plaintiffs or Akana's application for writ of certiorari, a motion to file amicus brief by OHA, our response that we filed in response to that. In addition, we've noticed a potential conflict by Justice Devins that he's noticed. These are all the public documents. One additional thing that's not listed on here, but the Supreme Court denied OHA's motion to file an amicus brief without prejudice, which is basically a lawyer's way of saying you can file again. And so the presumption is if certiorari is granted, OHA might try to file an amicus brief again. Again, these are all public documents. I'm just speaking, generally speaking, if there are specific questions, I'd advise that affect our rights, our liabilities, or sort of generally legal advice. It may be a situation where we may want to go into executive session. Just again, talking public document, OHA's proposed motion to leave the amicus brief largely adopts, I think, some of the arguments that Akana has, just essentially arguing that OHA is semi-autonomous in the Constitution, therefore they are a political subdivision, therefore they are similar to the counties and that they should have their own ethics commission and not be regulated. We are in the process of drafting our response to the writ for certiorari that is due tomorrow, or sorry, Friday, I believe, and we'll be addressing all of those questions, and I'm pretty confident in our response.
Timeline.
Again, my crystal ball is no better than anyone else's. However, I think the Supreme Court has a much lesser workload in comparison to the ICA, and so they've been much faster. My presumption would be is that we would likely have this all resolved in 6 months, but that's a crystal ball, right? So if the Supreme Court denies the certiorari, then it will happen pretty quick.
Yeah, that was my question. What's the deadline for the Supreme Court to issue a grant certiorari or not? Before our next meeting, probably.
I'm not sure, actually, and so let me not mislead you. It's something we can look at and get you an answer.
Yeah, but you just
but again, typically, just as a pragmatic matter, it will be a relatively quick thing.
Yeah.
And there are no further. So we still get a chance to file our reply, and then there are no, generally speaking, additional briefs. If an amicus brief is filed, that will go there, and we get to reply to that. So that's sort of timeline-wise built into it. But the presumption is the Supreme Court, if they take it, will move pretty quickly. If they deny it, that's it. It's done.
Everybody understand that? So we're hoping for a denial. If not, hopefully a quick, quote unquote, quick resolution. I always say that I hope that it's resolved before our tenure ends. It's like a real, no, I'm joking. Any questions from the commissioners on the Akana case? I know you're supposed to not too long ago. I've lived for 6, 7 years. Any questions? Any questions from the public in regards to the Akana case? Okay, discussion of cash status, is that?
We are resolved with number 1, so we're now on item number 8.
Oh, okay. That's it then, huh? Anything else that any of the commissioners want to bring up? Commissioner Tobias? Commissioner Hall? Commissioner Thielen?
Yes, Chair, I
Sure,
was
go
just
ahead.
a little bit confused. Did we take a position on going ahead and supporting, introducing, those bills that did not make it through? With purpose clauses?
Chairman.
Did we
Sure,
need a
please,
motion?
please.
We don't need a motion at this point. Typically before the legislative session, we will prepare a legislative packet. And so these two bills would likely be part of that packet. We'd ask you to support that one.
Okay, with purpose clauses. All
Oh,
right, there we go. I like that.
Sesame Street. Anybody else? If not, it is 10:10. I'll entertain a motion to adjourn.
So many.
Move by Commissioner
Second.
Tobias, second by Commissioner Thielen. We need a roll call.
Yes, starting with Vice Chair Tobias,
Aye.
Commissioner Hall,
Aye.
Commissioner Thielen,
I
Chair.
And Chair votes aye, and no objections. Motion is carried. The meeting is adjourned. We'll come back in 10 minutes. Yeah, let's